So let's begin. Criminal law. So the first thing when we are studying about criminal law, and the first question that generally comes to mind is how is criminal law related to the business and why is it important? You see, if you look at these photos, consider these photos that you are seeing. You see, it is probably not the usual image that will be conjured by the MBA students or the students who are studying business administration, those who are dreaming of success in the business world. As you can see in these photos, all these men, they are being led by the police and they are probably also in handcuffs. However, you see, it's a sad reality for too many managers and executives of companies who commit crimes in the context of their professional lives. And this begs the question, like, how can the path from business success lead to a criminal conviction? And there are many reasons why something like this happens in daily life, because people sometimes fall into the wrong crowd at work and they do not know how to walk away, or sometimes the corporate culture and the leadership, it can contaminate a work environment, causing people to disregard the ethical behavior or to ignore the laws. I mean, the general concept is that if everyone is doing it, then someone might believe that it's okay for him or her to do it as well, even though that action might be unlawful or illegal. And being part of an organization has a way of making someone feel insulated and safe when committing wrongdoing. For example, when some members of this Enron workforce, they seemed to be swept up in a culture of this corporate greed, and they did not know how to walk away. You see, other people are opportunists, and their moral compass or ethics, it does not lead them away from the temptation. For instance, Bernie Madoff may be a prime example of such an opportunist in today's news. And sometimes the criminal behavior, it results from the emphasis of profit making over ethical behavior. For example, you see, when you think of these corporate environmental crimes in which the corporations decide not to follow the regulatory requirements regarding hazardous waste or disposal or storage, in the end, of course, the reasons for the criminal behavior, they do not matter. When a crime is committed, others will be injured and the wrongdoer will be subject to criminal prosecution. So everyone must be careful about not committing crime. Crimes affect businesses both from the inside as well as from the outside. Right. So as I was saying, so when you see these photos, when you see these images, you know that no matter what, when a crime is committed, there will be an injury. It will be the public at large, it can be the shareholder, it can be an individual person, and the wrongdoer will be brought to justice. The wrongdoer will be subject to the criminal prosecution. And everyone needs to be careful about not committing crime. You see, crime, as I said earlier, it affects businesses from the inside as well as from the outside. And even if individuals, they are honest in their dealings, that does not relieve them from the necessity to maintain a vigilant watch to protect not only their good name, but also that of their business from the criminal activities of others. I cannot just say that, oh, I did not commit any crime. But if you are seeing any crime being committed in your company, you have a duty to prevent that crime from being committed. You see, criminal activity from the outside can be costly to the businesses also. For instance, loss through property damage, or theft, or shoplifting, or corporate espionage, or fraud, arson. These are all real threats. And perhaps more insidiously, the threats from the inside also, they pose tremendous risk of loss. And what kind of threats are these? These activities can include crimes such as embezzlement, computer crimes, as well as fraud. And such insider jobs are perhaps, it's more unsettling because the perpetrators of these crimes are often, they can often be your trusted colleagues who would not ordinarily fall under the suspicion of others. And moreover, a corporation must also protect itself from the bad judgment or overzealous behavior of its own employees. If an employee acting within the scope of employment commits a crime from which the corporation itself will benefit, always remember then that the corporation can be convicted of that crime too. Of course, not all corporations that are convicted on criminal charges are helpless victims of an overzealous employee who commits crime on their behalf. There are other businesses as well that are actively involved in crime. Let's say whether through a corporate culture that's gone haywire or through outright organized crime, such as organizations that operate or do business in money laundering or involved in money laundering. And that's why it's very important to understand about criminal law in the context of the business world. Not only do we need to understand the basic criminal law and the nature of the crime in business to understand everyday headlines, but we also must ensure that our own professional dealings and the people associated with our businesses are never the legitimate focus of such stories. So our next question would be, what is crime? You see, when crime occurs in the workplace or in the context of a business, the temptation might be to think that no one is really injured. I mean, there's no dead body, no one is murdered, no one is hurt. So no one is really injured. After all, insurance policies can cover some of these losses. And sometimes also people think that the victims of crimes such as embezzlement, they do not, these victims, they do not immediately notice the embezzlement, and then they must not need that money somehow. And that's why they try to justify that no real crime has been committed. Of course, these are just excuses and these are just smoke screens. You see, when an insurance company has to pay for the claim arising from a crime, the insurance company is injured. And who else is injured? There are also victims, the people in the society, as well as the society at large. Similarly, the fact that the wealthy people or the businesses, they do not notice this embezzlement immediately does not mean that they are not entitled to retain their property. You see, crime undermines the confidence in the social order, the expectations that we all have about living in a civil society. You see, no crime is actually victimless. If there is a crime, there is a victim, be it an individual, the company, the shareholders, or the society. So it's important to understand that a crime is a public injury. At the most basic level, criminal statutes reflect the rules that must be followed for a civil society to function. Crimes are an offense to civil society and its social order. In short, one can say that crimes are an offense to the public, and someone who commits a crime has committed an injury to the public. Now let's talk about the elements of crime. So what are the elements of crime? You see, there are 4 elements of crime. First is the criminal act or actus reus. Second is the criminal intent or mens rea. And then the concurrence and the causation. Let's discuss about them one by one. First is the actus reus or the criminal act. You see, this is generally defined as an unlawful bodily movement. Note that one requirement of criminal act is that the defendant must perform it voluntarily. In other words, the defendant must be controlling his or her action. It would not serve the policy of specific deterrence to punish the defendant for irrepressible acts. The Model Penal Code, it gives the following examples of acts that are not voluntary and therefore not criminal. What are these examples? For instance, let's say the reflexes or convulsions or bodily movements during unconsciousness or sleep, such as sleepwalking, or any kind of conduct during a hypnosis session or resulting from a hypnotic suggestion. or a bodily movement that otherwise is not a product of the effort or determination of the actor, either conscious or habitual. Note that one voluntary act is enough to fulfill the voluntary act requirement. Thus, if a voluntary act is followed by an involuntary one, the court may still impose criminal liability depending on the circumstances of the case. Let's take an example of an involuntary and non-criminal act. So, what is this involuntary act or a non-criminal act? Let's take an example. Jack is hypnotized at a local county fair or local town fair. The hypnotist directs Jack to smash a banana cream pie into his sister Jill's face. Now you see, smashing a pie into a person's face will be a battery in most states. But Jack did not commit the act voluntarily, so he should not be convicted of the crime of battery. Punishing Jack for battery would not specifically deter Jack from performing the act again while hypnotized. Why? Because he is not in control of his behavior when experiencing this mental state of hypnosis. How about an example of a voluntary act followed by a non-voluntary act? Here's an example. Jack attends a party at a friend's house, let's say, and consumes several glasses of red wine. And Jack then attempts to drive his vehicle home. And while driving his vehicle, his car, Jack passes out, he becomes unconscious at the wheel and he hits another vehicle, killing its occupant, Jill. Now, Jack can probably be convicted of one or more crimes in this kind of a situation. You see, Jack's acts of drinking several glasses of wine and then driving a car are voluntary. And even though Jack got into a car accident while he was unconscious, his involuntary act was preceded by a conscious and controllable and voluntary action. Conscious, controllable, and voluntary action. These three are important words. A punishment, you see, in this case, therefore, could specifically deter Jack from drinking and driving on another occasion and will be appropriate based on the circumstances. How about criminal thoughts? You see, thoughts are a part of criminal intent, not a criminal act. Thoughts alone cannot be criminalized. Let's take an example of a non-criminal thought. Let's say Jennifer, a house cleaner, she's fantasizing about killing her elderly client Phoebe and stealing all her jewelry. Now Jennifer writes her thoughts down in a diary, documenting how she intends to rig the gas line so that the gas is pumped into the house all night while Phoebe is sleeping. And by inhaling that gas, Phoebe will die. Jennifer includes the date that she wants to kill Phoebe in her most recent diary entry. And now as Jennifer leaves Phoebe's house, her diary accidentally falls out of her purse. Later, Phoebe finds the diary on the floor and reads it. Phoebe calls the police, gives them Jennifer's diary and insists that they arrest Jennifer for attempted murder. Now, although it is true that Jennifer's murder plot is sinister and it has been documented in detail in her diary, an arrest in this case will be improper. Why? Why cannot Jennifer be arrested? Because Jennifer cannot be punished for her thoughts alone. Thoughts alone is not a crime. If Jennifer, on the other hand, had taken substantial steps to kill Phoebe, an attempted murder charge might be appropriate. However, at this stage, Jennifer is only planning a crime. She is only putting down her thoughts on her diary and she is not committing any crime. Phoebe may be able to go to court and she may also be able to get a restraining order against Jennifer to prevent her from carrying out her murder plot. But Jennifer cannot be incapacitated by the arrest and prosecution for attempted murder in this case. How about omission to act? You see, an exception to the requirement of a criminal act element is omission to act. Criminal prosecution for failure to act is rare because the government is reluctant to compel individuals to put themselves in the way of any harm. However, under certain specific circumstances, omission to act can actually be criminalized. And omission to act can only be criminal when the law imposes a duty to act. And this legal duty to act becomes an element of the crime, and the prosecution must prove it beyond a reasonable doubt, along with proving the defendant's inaction under the circumstances. Failure or omission to act is only criminal in 3 situations. Remember, failure or omission to act is criminal in only 3 situations. What are these 3 situations? 1, when there is a statute that creates a legal duty to act, or 2, when there is a contract that creates a legal duty to act, or 3, when there is a special relationship between the parties that creates a legal duty to act. In other words, if there is a statute or a contract or a special relationship between 2 individuals or parties that creates a legal duty to act, and under such circumstances, if either one of the party fails to act, then such omission will be considered a criminal omission. It will be considered a criminal act. Legal duties in this case can vary from state to state and from also state to federal. Under the common law, you see, it was not criminal to stand by and refuse to help someone who is in danger. Some states have superseded the common law by also enacting something called the Good Samaritan statutes that create a duty to assist those who are involved in any accident or emergency situation. And these Good Samaritan statutes, typically, they contain provisions that insulate the actor from liability exposure when providing the assistance. So here is an example of a Good Samaritan law. As you can see here, under duty to assist, it says a person at the scene of an emergency who knows that another person is exposed to or has suffered grave physical harm shall, to the extent that the person can do so without danger or peril to self or others, give reasonable assistance. Give reasonable assistance. It says that the person should give reasonable assistance to the other person who has been exposed to harm. And reasonable assistance may include obtaining or attempting to obtain aid from the law enforcement or medical personnel. A person who violates this subdivision is guilty of a petty misdemeanor. That means if you see someone who is exposed to harm, you have a duty. You are compelled to help that person. And if you do not help that person, you will be guilty of a petty misdemeanor. And what does Subdivision 2 states? General immunity from the liability. A person who without compensation or the expectation of compensation renders emergency care, advice or assistance at the scene of an emergency or during a transit to a location where the professional medical care can be rendered is not liable for any civil damages as a result of acts or omissions by that person in rendering the emergency care, advice or assistance, unless the person act in a willful and wanton or reckless manner in providing the care, advice or assistance. Now, this subdivision does not apply to a person rendering emergency care, advice or assistance during the course of regular employment and receiving compensation or expecting to receive compensation for rendering the care, advice or assistance. However, though there are Good Samaritan laws which have been adopted by many states, sometimes trying to be a Good Samaritan may also have adverse consequences, as we will see in these videos.
Case from California. In 2004, a group of office workers headed home after a party, and they were involved in a car crash. One pulled a coworker from the car, fearing it would catch fire. The woman rescued was left a paraplegic and sued her coworker for treating her like a rag doll. Can a Good Samaritan be sued? Here's Mike Von Fremd in Los Angeles.
The California Supreme Court says Good Samaritans can be sued. The woman who was pulled out of this car can proceed with her lawsuit against the coworker who rescued her.
The problem is that you can't be careless when you're helping someone without consequence. The victim here said, I would have been better off if you had not tried to help me and let some professional come along rather than end up as a paraplegic for life.
Earlier this year, Stephanie DeLabio and her 2-year-old daughter were trapped inside this car during a terrifying flash flood.
And before I knew it, the water was rushing and took my car with it.
She says she and Amelia are alive today thanks to Good Samaritan David Rhodes.
It would have been too long. I don't think they would have made it if somebody wasn't there to help them get out.
But now Good Samaritans may want to think twice before stopping to help accident victims. And many feel the ruling flies in the face of human nature.
I think it's awful that we can't, as human beings, help each other without some kind of court ruling.
If I were in an accident on the side of the road, I would definitely want someone to step forward and not be afraid of the consequences of trying to help me.
Stephanie DeLabio says in life and death situations like hers, no one can afford to think twice.
People will think twice. If it hadn't been for David, I really don't think that my daughter and I would be here.
David Rhodes says the fear of lawsuits and bankrupting loved ones just for helping someone else has consequences.
I wouldn't want my family in jeopardy for me trying to help somebody else.
The backlash is so strong that the California legislature may rewrite the law to give more protection for Good Samaritans. Mike Von Fremd, ABC News, Los Angeles.
We report next on a controversial court.
This is a story that has two sides and a lot of different angles. You're about to hear it all. It involves a man with a checkered driving record, a government agency that broke down, and a big question. Should taxpayers be liable for this man's injuries? It was June 19, 2009, one of those days with on and off rain that leaves the paint kind of slick. A day when most drivers back off the gas pedal a bit. But Nick Otter isn't like most drivers. At 28, he'd racked up 9 infractions on his driving record, including careless driving, running a stop sign, and 2 citations for speeding. Otter was about to have his 5th accident in 4 years, and this one would be a doozy. As he rounded this sharp curve on Sandy Creek Road in Frenchtown Township, Otter slammed into the back of a fire truck. The bright yellow rig was stopped with emergency lights flashing, attending to another accident. A police dash cam was rolling and caught part of it on tape. Watch this part of your screen. You'll see Otter's pickup truck round the corner and disappear from the frame. Then you'll hear the impact and see his pickup slide back into frame.
Another crash. Guy ran into the back of the fire truck.
This sheriff's deputy and 2 other witnesses put the blame squarely on Dick Otter. In this police report, Deputy Robert Blair said that Otter's truck was traveling at a speed too fast for the curve, that it crossed the center line, and that the pickup hit the fire truck with such force it caused the pump truck to move forward slightly. Another witness, a tow truck driver, said that Otter was traveling at approximately 50 miles per hour, that his pickup drifted into the opposite lane and began to fishtail just before slamming into the fire truck.
He did pretty good.
Nick Otter was hurt badly. His leg was mangled and his lung punctured by broken rib. The firefighter, Fred Carter, who was manning the pumper truck, quickly fired up the jaws of life. He and other firefighters freed Otter from the wreckage and probably saved his life. Otter was ticketed for driving without insurance, and our investigation uncovered another troubling fact. Even the cops didn't know when he slammed into the fire truck. Otter shouldn't have been driving. These court records show a judge had previously suspended his license as part of Otter's probation for a drug conviction. The suspension should have been in effect at the time of the crash, but the Monroe County Clerk's Office dropped the ball and didn't notify the Secretary of State, so the suspension didn't go through. So you've got a guy whose license should have been suspended driving without insurance. Witnesses say he was going too fast and crossed the center line. And now Nick Otter is suing Frenchtown Township and the firefighter who helped save his life. You don't want to answer any questions? Nick Otter isn't talking. Come out here to the street.
I don't have a problem with that.
But you'll see things heat up when later Otter's mother tries to run interference.
Why is your client suing the fireman who helped save his life?
Otter's lawyer is talking, and he says, not so fast. This thing is not as cut and dried as it might appear.
The fireman ended up saving my client from an injury that may have been caused by the fireman.
John Kaplansky's version of what happened totally contradicts the witness statements. He says Otter was not speeding, as 3 witnesses said, and he did not cross the center line. Even though the fire truck appears to be right on the center line in these police photos, Kaplansky claims it was actually in Otter's lane, and it may have been moved back across the center line by the impact.
I'm saying the position of the vehicle, which may very well have been backing up at the time, not stationary, is the cause of the accident. Yeah.
Kaplansky points out that a flagman who had been slowing traffic left his post just before Otter came around the corner. Otter told police he encountered the truck and had no room to get around it. But look at these pictures. Does it look like he had room? And what about Otter's driving record? The fact that he was driving with no insurance and his license should have been suspended.
I am so glad you have the court record because
no insurance.
He didn't have any insurance, but he had a driver's license. I don't know where you got your information. Get the off my property.
Because he didn't have insurance, under no-fault law, Otter can't sue for anything except lost wages. But when the crash happened, he didn't have a job and hadn't worked for quite a while. This is Otter's estranged wife, married to him since 2006.
He didn't work for 2 whole years. Even when the unemployment ran out, he promised me he would do anything. And he wouldn't do nothing.
In his lawsuit, Otter claims he's disabled and can't work. So we asked his lawyer, why?
We see blind people working, people in wheelchairs working, people with closed head injuries working. Isn't there something he could do to earn a living?
I don't know that he'll never work. I know that some jobs he'll probably be incapable of due to disability.
Otter's wife told the investigators her husband is very active. He even goes snowmobiling and jet skiing. When the investigators first caught him on undercover camera, Otter was walking with a limp but getting around fine, in and out of his truck, up and down stairs, and walking at a pretty good clip. Is your leg injured, Nick?
Yeah, it is. Big time. It's broke.
But check this out. Now he knows the camera is on him, and the limp looks worse. Ultimately, a jury will probably decide who should be held responsible in this crash. The attorney for Frenchtown Township declined to comment, except to say that his plan at this point is to take this case to trial. Monroe County's clerk is accepting full responsibility for the mistake that kept Nick Otter's license from being suspended. Sharon LeMasters tells the investigators it was a clerical error. She said she realized recently that they had a problem with their procedures, and they brought the Secretary of State in for training. LeMasters says she's confident the problem has been fixed, and this will not happen again. Scott Lewis, Channel 7 Action News.
Could you be punished for being a hero? That might just be the case in our next story. Have a look at this one.
It was a video that went viral, seen all across the country. A 58-year-old Craig Jerry enjoying his drink at the Starbucks. Suddenly, a man wearing a Transformers mask pulls out a gun and a bag, demanding money from the barista. Fresno police identify the suspect as 30-year-old Ryan Flores. In the video, Jerry is seen hitting Flores with a chair, and a violent fight ensues. Investigators say Jerry was stabbed in the neck during the struggle, but managed to wrestle away the knife and stabbed Flores several times. Chief Jerry Dyer called the Good Samaritan a hero, but Flores' mother, Pamela Clemente, says her son is a victim too.
He has 17 total stab wounds, lacerations, and defensive wounds.
Clemente says Jerry used excessive force with trying to stop her son from allegedly robbing the Starbucks.
Guy, in my opinion, went from a good Samaritan to a vigilante.
Now, Clemente says her son plans on filing a lawsuit against Jerry for that alleged excessive force.
Wow is right. Wow. You hear this story and you see the footage, and of course you're all asking yourself, would I be brave enough to do what that individual did? Mary, is there a case here? Is there a possibility that the Good Samaritan? Okay, but is it a good case? Could this Good Samaritan end up in trouble?
He could. And, you know, what we do is in the law, we have this fancy term, and it's called reasonable. Did he reasonably believe that he needed to step in to defend because you have a right to defend others? And then was his actions reasonable given the circumstances of what was going on?
Well, so Mary, to that point, I was watching the footage. Is it reasonable that he was first stabbed? And then you can see that he's still wrestling. There's no control over that person. And that's why he was stabbing, right? So what do you think about
Question that needs to be asked is, was he using excessive force? And, you know, you have to put yourself in his shoes at that time. He got stabbed in the neck. You can
That's a life
injury.
And I mean, the head neck surgeon, somebody stabs me in the neck, I think I'm going to die.
And from what I would
fighting
agree.
for my life.
From what I've seen, I would agree.
You got this cortisol output, right? So you're wrestling. It's like we're all here in hair and makeup, and I think 2 stabs back would have been reasonable, not 7.
Right. You know what I mean? Like,
Can I say, if you, Mary, I know I am not in the legal system. I'm not a lawyer. If you walk into a store with a gun and a knife, and you do that, to me, you should lose your rights as far as when a scenario like that happens, you've lost your rights. Because I am so sorry, but if that were me, and I'm sitting there having a sandwich, and I see that go down, and if I have the courage to try to stop this individual, the amount of adrenaline running through my system, medically speaking, is so intense, I cannot imagine just the reflexive nature. And so how
fight
do
or flight response, like you said.
Exactly.
But
fight or flight is not even frontal lobe anymore. That's
even
just survival.
Kabam was sticking up for her son, who walks into this Starbucks with a knife. My baby, oh, well, my poor baby. He beat him up. He shouldn't have beaten him up so badly.
But Drew, how can you blame the mom if we live in a system where she has a chance of winning this case?
I know.
That's my point. Is
well, I wouldn't want you on the jury if I was the attorney.
I don't
want
any of us on the jury.
But can you, as a judge, can you just throw this case out if you do not believe it has merit?
Question of fact, was the force excessive? I mean, and that's what needs to be considered, and that's what a judge, if that person is a trier of fact or a jury, would decide.
I mean, if this all went down and then the guy surrendered and said, no, and then the guy grabs the gun and shoots him, I understand that. But I mean, if a guy's attacking you and you're just trying to subdue him, okay. Anyway, this one, when I read this story, I was fired up.
Okay, so what does these 3 videos they teach us? It's quite simple actually. It teaches us that yes, go ahead, be a good Samaritan, go and help others who are in need. But at the same time, you must be careful. While you're rescuing someone, do not make matters worse for the person that you're rescuing. And let's continue with criminal law. The next topic is elements of crime. So when we talk about elements of crime, we have to first understand a few duties. The first is the duty to act based on a contract. You see, a duty to act can be based on a contract between the defendant and another party. And the most prevalent examples would be a doctor's contractual duty to help a patient, or a lifeguard's duty to save someone who is drowning. So keep in mind that the experts who are not contractually bound can ignore an individual's pleas for help without committing a crime, no matter how morally abhorrent that may seem or look. For example, an expert swimmer can watch someone drown if there is no statute or contract or a special relationship that creates a legal duty to act. Next is duty to act based on a special relationship. A special relationship, you see, may also be the basis of a legal duty to act. The most common special relationship are parent-child or spouse-to-spouse and employer-employee. Often the rationale for creating a legal duty to act when people are in a special relationship is the dependence of one individual on another. A parent has the obligation by law to provide food, clothing, shelter, and medical care for his or her children. Because, why? Because the children are dependent on their parents and they do not have the ability to procure these items themselves. In addition, if someone puts another person in peril, there may be a duty to rescue that person. You see, although this is not exactly a special relationship, the victim may be dependent on the person who created that dangerous situation itself, because he or she may be the only one present and able to render the aid. And on a related note, also remember that some jurisdictions may also impose a duty to continue to provide the aid once aid or assistance has started. And similar to the duty to rescue a victim the defendant has put in peril, the duty to continue to provide aid is deeply rooted in the victim's dependence on the defendant and the unlikely chance that another person may come along to help once the defendant has begun providing the assistance. How about an example of a failure to act that is non-criminal? Let's take an example. Let's take the example of Jack and Jill, who are shopping together, and Jack stands by and watches as Jill shoplifts a dress. She's a shoplifter. In this example, you see, Jack does not have a duty to report Jill of shoplifting. Jack does not have a contractual duty to report the crime in this situation. Why? Because he's not a law enforcement officer. He's not a police officer. He's not a security guard who is obligated by an employment contract. Nor does he have any special relationship with the store mandating such a report. And unless a statute or an ordinance exists to force individuals to report crimes committed in their presence, which is extremely unlikely, Jack can legally observe Jill's shoplifting without reporting it. However, note that if Jack is assisting Jill with the shoplifting, for example, let's say Jack is shielding Jill while she is shoplifting so that no one can see Jill commit the shoplift. In this kind of a situation, Jack has knowingly and intentionally, he has performed a criminal act, also known as actus reus, that is by aiding Jill in shoplifting, and in such a case, a criminal prosecution will be appropriate. Now let's discuss about a failure to act that is criminal. Let's take an example. Let's say Jack stands on the shores at a public beach and he watches as a child drowns. A child is drowning, Jack is standing on the shore of a public beach. Now, if Jack's state has a good Samaritan law, he may have a duty to help the child based on a statute. And if Jack is the lifeguard, he may have a duty to save the child based on a contract. And if Jack is the child's father, he may have a duty to provide assistance based on their special relationship. Now, if Jack threw the child in the ocean, he may have a duty to rescue the child he put in peril. If, however, Jack is just a bystander and no good Samaritan law is in force, he has no duty to act and cannot be criminally prosecuted if the child suffers harm or if the child drowns. How about possession as a criminal act? What about possession? Can possession be a criminal act? You see, although it is passive rather than active, possession is considered a criminal act. The most common objects that are criminal to possess are, of course, illegal contraband, drugs, and weapons. So there are two types of possession you have to know. One is called actual possession and constructive possession. And actual possession indicates that the defendant has the item on or very near his or her person. And constructive possession indicates that the item is not on the defendant's person, but is within the defendant's area of control, such as inside the house or an automobile with the defendant. And also note that because possession is passive, possession should be knowing, meaning that the defendant is aware or has the knowledge that he or she possesses the item. How about an example of an unenforceable possession statute? Well, in this regard, it's important to note that some possession statutes can be unenforceable under certain circumstances. Let's say a state has a criminal statute that prohibits being within 100 feet of any quantity of marijuana. Now Jack sits next to Jill on the subway. A law enforcement officer smells marijuana and does a pat-down search of Jill. And he discovers that Jill has a large bag of marijuana in her jacket pocket, and he arrests both Jill and Jack for marijuana possession. Now Jack was within 100 feet of marijuana as prohibited by the statute, but can Jack be prosecuted? The answer is no. Jack cannot and should not be prosecuted for marijuana possession. Why? Because no evidence exists to indicate that Jack knew Jill or knew that Jill would be possessing marijuana. Thus, Jack does not have the criminal intent or the mens rea for possession, and the state's possession statute should not be enforced against him. Okay, now how about criminal intent or mens rea? Criminal intent or mens rea. Although you see there are exceptions that we will be discussing shortly, criminal intent or mens rea is an essential element of most crimes. Under the common law, all crimes consisted of an act carried out with a guilty mind. And in the modern society also, criminal intent can be the basis for fault and punishment according to the intent that it is a core premise of criminal justice. Now, here is a statutory example: intent to cause death of another person. Note that the grading is often related to the criminal intent element. Crimes that have an evil intent are malum in se and subject the defendant to the most severe punishment. And the crimes that lack the intent element are less common and are usually graded much lower as either misdemeanors or infractions or petty offenses. Now, what do we mean by malum in se? In Latin, this means an act that is wrong in itself, in its very nature being illegal, because it violates the natural, moral, or public principles of a civilized society. And in criminal law, it is one of the collection of crimes which are traditional and not just created by a statute, which are malum prohibitum. For example, murder, rape, burglary, and robbery, these are all malum in se, while violations of the Securities and Exchange Act or most white-collar crimes, these are malum prohibitum. So what is malum prohibitum? In Latin, it means wrong due to being prohibited, which refers to the crimes made so by the statute as against or compared to the crimes based on the English common law and obvious violations of the society standards, which are defined as malum in se. Statutory crimes include criminal violations of regulatory acts or white-collar crimes such as improper use of insider information, issuance of stocks without a permit, which are intentionally not supported by the real assets of and tax avoidance. And states and the federal government, they often vary in their approach to defining criminal intent, and each jurisdiction describes the criminal intent element in a criminal statute or case in jurisdictions that allow common law crimes. Now let's take a look at the common law criminal intent. You see, the common law criminal intents are ranked in order of culpability, and these are malice aforethought, specific intent, and general intent. And statutes and cases, they use different words to indicate the appropriate level of intent for the criminal offense. So let's take a look at the basic description of the intent definitions that are adopted by the many jurisdictions. Let's start with malice aforethought. You see, malice aforethought is a special common law intent that's designed for only one type of crime. And what is that? Murder. Malice aforethought is a special common law intent that's used for only one type of crime, that's called murder. And the definition of malice aforethought is basically intent to kill. Malice aforethought means intent to kill. You see, society considers intent to kill the most evil of all intent. So malice aforethought crimes such as first and second degree murder, they generally mandate the most severe of punishments, including the death penalty in the jurisdiction that allow for it. And less serious is the specific intent. Specific intent. You see, specific intent is the intent with the highest level of culpability for crimes other than murder. Unfortunately, criminal statutes rarely describe their intent element as specific or general, and a judge may be required to define the level of intent using the common law or a dictionary to explain a word's ordinary meaning. And typically, you see, specific intent means that the defendant acts with a more sophisticated level of awareness. A more sophisticated level of awareness. Crimes that require specific intent usually falls into one of the three categories. Either the defendant intends to cause a certain bad result, or the defendant intends to do something more than commit the criminal act, or the defendant acts with the knowledge that his or her conduct is illegal, which is also known as a scienter. An example of a specific intent to bring about a bad result. Let's take an example. Let's say a state statute, it defines mayhem, M-A-H-Y-E-M, mayhem, as a physical contact with another inflicted with the intent to maim, disfigure, or scar. And this statute describes a specific intent crime. To be guilty of mayhem under the statute, the defendant must inflict the physical contact with the intent of causing the bad result of maiming, disfigurement, or scarring. Now, if the prosecution cannot prove this high-level intent, the defendant may be acquitted or charged and convicted of a lower-level intent crime like battery. So let's say, let's take this example. If Priscilla says that it's time to permanently mess up that pretty face, and thereafter takes out the razor and slices Peter's cheek with it, Priscilla might be found guilty of mayhem. On the other hand, if Priscilla slaps Peter while he's shaving without making the comment and the razor bites into his cheek, it is more challenging to prove that she intended a scarring, and Priscilla might be found guilty only of battery. Now let's take an example of specific intent to do more than a criminal act. Let's say a state statute defines theft as a permanent taking of a property belonging to another. That's the definition of theft. And this statute describes a specific intent crime. Theft is a specific intent crime. And to be guilty of theft under the statute, the defendant must intend to do more than take the property of another, which is the criminal act. And what is this intent to do more? That means the defendant must also intend to not only take the property of another, but also to keep that property permanently himself. So if Priscilla borrows Peter's razor to, let's say, shave her legs, she has taken the property of another. That's fine. But has she committed theft? The answer is no. She has not committed theft for the simple reason that she intends to return the property after use, and she has no intention of keeping the property permanently. How about an example of a scienter? You see, although the terms mens rea and scienter are sometimes used interchangeably, many jurisdictions, they define scienter as the knowledge that an act is evil or illegal. It's a knowledge that an act is illegal. And scienter can be the basis of specific intent in some statutes. So a statute that makes it a crime to willfully file a false tax return may require knowledge that the tax return includes false information and that it will be unlawful to file it. So if the prosecution fails to prove beyond a reasonable doubt that the defendant knew his or her conduct was illegal, this could nullify that scienter, and the prosecution cannot prove specific intent in this case. How about general intent? You see, general intent, when you speak about general intent, it is less sophisticated than specific intent. And therefore, general intent crimes are easier to prove and can also result in a less severe punishment. A basic definition of general intent, it can be said to be the intent to perform the criminal act or actus reus. Now, if the defendant acts intentionally but without the additional desire to bring about a certain result or do anything other than the criminal act itself, the defendant has acted with a general intent. Now, you see, let's talk about inference of general intent. You see, intent is a notoriously difficult element to prove because why? Because it is locked inside the defendant's mind. Ordinarily, the only direct evidence of intent is a defendant's confession. If a defendant confessed that he intended to commit the crime, then it's fine. However, without that, it's very difficult to prove what is going on in the defendant's mind. And defendant's confession, if the government cannot forcibly, also they cannot forcibly or forcefully obtain the defendant's confession because of the Fifth Amendment privilege against self-incrimination. So without this defendant's confession, it's very, very difficult to get that evidence of intent. Witnesses who hear the defendant express intent are often unable to testify about it because of also evidentiary rules prohibiting hearsay. However, many jurisdictions have allowed an inference of general intent based on the criminal act. In essence, you see, if the jury accepts the inference, the prosecution does not have the burden of proving intent for a general intent crime. Now let's talk about an example of a general intent crime and an inference of intent. You see, a state statute defines battery as intentional, harmful, or offensive physical contact with another. Now, this statute describes a general intent crime. Battery is a general intent crime. Now, to be guilty of battery under the statute, the defendant must only intend the harmful or the offensive contact. The defendant does not have to have the desire that the contact produces a specific result such as scarring or death, nor does the defendant need any scienter, nor awareness that the physical contact is illegal. Let's take an example. If Jack balls up his fist and punches Jill in the jaw after Jill calls him a stupid idiot, Jack has probably committed battery under the statute. A prosecutor also could prove that Jack committed the act of harmful or offensive contact using Jill's testimony and a physician's report. The jury could therefore be instructed to infer the intent from the proof of that. Now, if the jury accepts the inference and determines that Jack has committed the criminal act, the jury could find Jack guilty of battery without additional evidence of intent. Now, how about motive? How about motive? You see, we have to understand the difference between intent and motive. We have to understand the difference between intent and motive. Intent should not be confused with motive, which is the reason the defendant commits the criminal act or the actus reus. So motive is the reason. Motive is different from intent. Motive is the reason behind the defendant's action of committing the criminal act or the actus reus. Motive can generate an intent, support a defense, and be used to determine sentencing after the trial is over. However, motive alone does not constitute mens rea. Very important. Motive is not the same as intent, and motive alone does not constitute mens rea and does not act as a substitute for criminal intent. Let's take an example of a motive. Jill, a housewife with no criminal record, sits quietly in the court waiting to hear the jury verdict in a trial for the rape of her teenage daughter by Jack. Now, Jack has been convicted of child rape in 3 previous incidents. The jury foreman announces the decision finding Jack not guilty. Now, Jack looks over his shoulder at Jill and smirks. And what does Jill do? Jill then calmly pulls a loaded revolver out of her purse and then shoots and kills Jack. In this case, you see, Jill's motive is revenge for the rape of her teenage daughter or the desire to protect other women from Jack's conduct. And this motive generated Jill's criminal intent, which is the malice aforethought or the intent to kill Jack. And in spite of Jill's motive, which is probably understandable under the circumstances, Jill can be found guilty of murder because she acted with the murder mens rea. However, Jill's motive may be introduced at sentencing and it may result in a reduced sentence such as life in prison rather than the death penalty. And in addition, Jill's motive may also affect the prosecutor's decision to seek the death penalty at all because this would probably be disfavored by the public. Now let's talk about criminal intent under the Model Penal Code. The Model Penal Code. You see, the Model Penal Code, it divides criminal intent into 4 states of mind listed in order of culpability. And what are these? These are purposefully, knowingly, recklessly, and negligently. What is purposely? You see, a defendant who acts purposely, he intends to engage in a conduct of that nature and intends to cause a certain result. Let's take the example of Priscilla. Priscilla takes out a razor and slices Peter's cheek. In this example, you see Priscilla is aware of the nature of the act, that is slicing someone's cheek with a razor. Priscilla also appears to be acting with the intent to cause a specific result based on her statement to Peter. Thus, Priscilla is acting with a specific intent or purposely and can probably be convicted of some form of aggravated battery or mayhem in most jurisdictions. Next is knowingly. What is knowingly? You see, knowingly indicates that the defendant is aware of the nature of the act and its probable consequences. And knowingly differs from purposely in the sense that the defendant is not acting to cause a certain result, but is acting with the awareness that the result is practically certain to occur. Now let's take an example. Jack brags to his girlfriend Jill that he can shoot into a densely packed crowd of people on the subway train without hitting any of them. And Jill dares Jack to try it. And Jack removes a concealed weapon from his waistband and shoots, aiming at a group of people standing with their back to him. The shot kills Jill. The shot kills not Jill but Monica, who is standing the closest to Jack. And in this case, Jack did not intend to shoot Monica. In fact, Jack's goal was to shoot and miss all the standing subway passengers. However, Jack was aware that he was shooting a loaded gun, which is the nature of the act, and was also practically certain that shooting into a crowd would result in someone getting hurt or killed. Thus, what has Jack done? In this case, Jack has acted knowingly according to the Model Penal Code. And if the state in which Jack shoots Monica defines murder intent as knowingly under the Model Penal Code, then Jack has most likely committed murder. How about recklessly? You see, recklessly is a lower level of culpability than knowingly, and reckless intent crimes are not as common as offenses criminalizing purposeful or knowing conduct. The degree of risk awareness is key to distinguishing a reckless intent crime from a knowing intent crime. Defendant, you see, he acts recklessly if he or she consciously disregards a substantial and unjustifiable risk that the bad result or harm will occur. That is the definition of recklessness. Consciously disregards that a substantial and unjustifiable risk of harm will occur. And this is different from a knowing intent crime, where the defendant must be practically certain of the bad results. The reckless intent test, you see, is two-pronged. First, the defendant must consciously disregard a substantial risk of harm. The standard is subjective also, that is, the defendant must know of the substantial risk. And second, the defendant must take an unjustifiable risk, meaning that there are no valid reason exists for the risk. And the standard for this prong is objective. If a reasonable person would not take the risk, then the defendant's action in taking it is recklessness. Let's take an example where Jack shoots into a crowd of subway passengers and kills Monica. Now, let's change the example and imagine that the subway train has only 3 passengers, Jack, Jill, and Monica. Now, Jack easily shoots in between them, and yet the bullet ricochets off one of the seats and strikes Monica, killing her. Jack would be acting here in this case with recklessness rather than knowing intent in this situation. Why? Jack's knowledge and aware of the risk of injury or death when shooting a gun inside a subway car containing 3 passengers is probably substantial. And a reasonable law-abiding person would probably not take this action under these circumstances. So in this case, Jack might be charged with a lower level form of criminal homicide, like manslaughter in this case. Now let's talk about negligence. Negligent intent crimes are less culpable than reckless intent crimes and are also less common. The difference between recklessness and negligent intent is the defendant's lack of awareness. While the defendants committing negligent intent crimes are also faced with a substantial and unjustifiable risk, here remember that they are unaware of it, even though a reasonable person would be. Thus, the first prong of the reckless intent test is simply changed from a subjective to an objective standard. Let's take the example where Jack shoots into a crowd of subway travelers and kills Monica. Now let's change the example and imagine that the subway train has no passenger. Now Jack brags to Jill, the only 2 passengers in that train are Jack and Jill. Now Jack brags to Jill that he can shoot a crumpled napkin or a tissue roll on the floor, and Jill also challenges him to try it. Now Jack shoots at the napkin and misses, and the bullet ricochets, let's say 4 times of 4 different seats, travels backward in the air and strikes Jill in the forehead, killing her instantly. Now in this case, you see, Jack may be unaware of the bullet's potential to ricochet several times and actually travel backward. However, the trier of fact can determine that a reasonable person would be aware that shooting a gun inside a small subway train could result in injury or death. And this would be a finding that Jack had acted negligently under the circumstances. And if the state in which Jack shot Jill criminalizes negligent killings, then Jack could be found guilty of criminal homicide in this case. Now let's talk about some exceptions to the requirement of criminal intent. Exceptions to the requirement of criminal intent. So what are these? First is the strict liability. You see, an exception to the requirement of a criminal intent element is strict liability. And strict liability offenses, they have no criminal intent. Strict liability is a model statutory trend, and it abrogates the common law approach that behavior is only criminal when the defendant commits acts with a guilty mind. Sometimes the rationale for strict liability crimes is the protection of the public's health, safety, and welfare. So, strict liability offenses are often what kind of offenses? You will find this kind of offenses under the vehicle code or tax code violations, and they generally mandate a less severe punishment. And with a strict liability crime, the prosecution only has to prove the criminal act and possible causation and harm or attendant circumstances depending on the elements of the offense. Let's take an example of a strict liability offense. A vehicle code provision makes it a crime to travel in a vehicle over the posted speed limit, and this is a strict liability offense. So if a law enforcement officer, it captures radar information that indicates Susan was traveling in a vehicle, let's say 5 miles per hour over the posted speed limit, Susan can probably be convicted of speeding under the appropriate statute. And Susan's protest that she did not know that she was traveling at that speed is not a valid defense. You see, Susan's knowledge of the nature of the act is totally irrelevant. The prosecution only needs to prove the criminal act, that is, Susan was traveling or driving her car over the speed limit, in order to convict Susan, because this statute is a strict liability and does not require any proof of any criminal intent. How about transferred intent? Let's discuss about the concept of transferred intent. You see, occasionally the defendant's criminal intent is not directed towards the victim, and depending on the jurisdiction, this may result in a transfer of the defendant's intent from the intended victim to the eventual victim for the purpose of fairness. Let's take an example to understand this better. You see, Billy and his brother Bob, let's say they get into an argument at a crowded bar. Now Billy balls up his fist and swings his fist aiming for Bob's face. Now Bob ducks, and instead of punching Bob, Billy punches Amanda, who was sitting next to Bob. Now Billy did not intend to cause battery to Amanda. However, it is unjust to allow this protective action of Bob's to excuse Billy's conduct. Bob has a right to protect himself. That's why he ducked. And that's why Billy ended up hitting and punching Amanda. So you see, Billy's intent to hit Bob in this case has transferred in some jurisdiction over to Amanda. And Billy can also be charged with attempted battery, which is assault of Bob, resulting in 2 crimes rather than 1 under the transferred intent doctrine. So in this example that we took, Billy has committed the crime of battery on Amanda, and Billy has also committed the crime of attempted battery on Bob by virtue of transfer intent doctrine. How about vicarious liability? Let's discuss about vicarious liability. You see, vicarious liability, it transfers a defendant's responsibility for a crime to a different defendant on the basis of a special relationship. And under the theory of vicarious liability, the defendant does not need to commit the criminal act supported by criminal intent. The defendant just has to be involved with the criminal actor in a legally defined relationship. Also, as in civil law, vicarious liability is common between employers and employees. And note always that corporate liability is a type of vicarious liability that allows a corporation or a company to be prosecuted for a crime apart from its owner, agent, and employees. And this is a modern concept that did not exist at early common law. You see, although corporations cannot be incarcerated, they can always be fined. Let's take an example. David hires James to work in his liquor store. Now, James is specially trained to ask for the identification of any individual who appears to be under the age of 30 and attempts to buy alcohol. And one night, James sells alcohol, let's say, to Ashley and does not request identification because Ashley is attractive and James wants to ask her out on a date. Now, unfortunately, Ashley is underage and is participating in a sting operation with the local law enforcement. And certain statutes could subject David to a criminal prosecution for selling alcohol to an underage person like Ashley, even though David did not personally participate in the sale. It is not David who sold the alcohol to Ashley. It was James who sold the alcohol to Ashley. But because David is James' employer, David may be vicariously liable for James' on-the-job conduct in this instance. Right? Now, let's also look at the last two elements of crime, that is concurrence and causation. Concurrence and causation. You see, concurrence, this is an element of a crime and it refers to the coexistence of a criminal intent and a criminal act. That means there should be some tie-up between the criminal intent and the criminal act. It should be related. And without evidence that the mens rea had preceded or occurred at the same time as the actus reus, the burden of proof, it will fall short. Okay, how about causation? You see, much of the time, this fourth element of crime is present in a criminal case. Causation, what is causation? Causation refers to the relationship between the defendant's conduct and the end result. The prosecution must prove beyond a reasonable doubt that the defendant's actions were what led to the resulting crime in question. This is typically a harm or an injury. Now let's take a look at a video that explains the elements of a crime.
The crime series from the Whitlam channel. Today we're going to look at the elements of crime. The two fundamental elements that need to be proved for something to be a crime are mens rea and actus reus. These are both Latin terms meaning guilty mind and guilty act. Let's look at mens rea to start. This is the hardest element to prove because it has to do with the mind, and we can't always tell what people are thinking or what they know. Fundamentally, mens rea looks at the motive and intent of the person who's accused of committing the crime. In order to prove mens rea, you need to show A, that they meant to do it, and B, that a reasonable person would have been aware of the consequences of their action. You might be sitting there at this point thinking to yourself, well, how are they going to prove that I meant to go over the speed limit in my car? Well, that's an example of what's called a strict liability offence. These are offences where you don't need to prove mens rea. That's because they're usually summary or less serious offences, and there's a greater volume of these. The logic goes, if you have your driver's licence, you should always have control of the car, and it's assumed knowledge that you are to obey the speed limit. So we don't care if you meant to or not. You shouldn't have been speeding. Essentially, this speeds up the process of those people being charged with those types of offences. Now let's look at actus reus. This element of crime is usually much easier to prove and comes down to the simple fact, did they actually do it? And usually the answer is much easier to find out due to physical evidence, witness testimony, and forensics. Again, you might be sitting there thinking, well, maybe they could prove that I did an act. That doesn't actually mean that the consequences of that act were caused by my action. This question is a subset of actus reus, and it's called causation. In other words, was the crime a direct consequence of their action? Or perhaps was it merely an unfortunate coincidence or caused by something completely unrelated? For example, I might be angry with my uncle at Christmas and hit him with a baseball bat and he has a heart attack and dies. Now, there's every chance that that's what caused the heart attack, but perhaps my uncle was incredibly unfit and would have had a heart attack anyway. Or perhaps we have a really strong family history of heart attacks, in which case that needs to be taken into account as to whether I'm charged with just assault or with manslaughter. In other words, did hitting him with the bat cause him to die, or was it an unrelated consequence? In order to prove actus reus, you need a direct link from action to result. So in any court case, the prosecution is trying to prove mens rea and actus reus, because they're the two fundamental elements of a crime. This has been another video for the crime series from Woodland Channel. If you want to see more of
Okay, now let's go on to the next topic, that is classification of crimes. You see, in every state, crimes are classified into distinct categories. The categories are usually felony, misdemeanor, and the third one is infraction or petty offenses. And the decisions on crime classification, these are made by the state legislatures, and the determination focuses on the seriousness of the crime. Let's start with infraction or petty offenses. You see, infractions, sometimes also called violations, are petty offenses that are typically punishable by the fine, but not jail time. Because infractions cannot result in a jail sentence or even probation, the defendants charged with infraction do not have a right to a jury trial. The defendant who has been charged with an infraction can hire an attorney, but the government does not have a constitutional duty to appoint one for the defendant. And often the prosecutors don't appear on behalf of the government in cases involving infractions. Traffic offenses are the most common form of infraction or petty offenses. And note that some states consider certain kind of infractions like traffic tickets to be even a civil rather than criminal offenses. How about an infraction example? Let's say Ginger receives a speeding ticket, and after Ginger and the officer who issued the ticket testify, the judge concludes that Ginger was speeding, and Ginger's punishment will be limited to a fine and the addition of a point to her driving record. How about misdemeanor? You see, misdemeanors are criminal offenses that carry up to a year in jail in most of the states. And some states have made the maximum imprisonment for many or all misdemeanors as 364 days. That is, it's up to a year. And that change is designed to avoid deportation consequences that would have been triggered if the misdemeanor in question carried the possibility of, or if the misdemeanor defendant actually received a full 1 year sentence. And punishment for misdemeanors can also include payment of a fine, a probation, or a community service, and restitution. So defendants charged with misdemeanors are often entitled to a jury trial, and indigent defendants charged with misdemeanors are usually entitled to a legal representation at the government's expense. And some states subdivide misdemeanors by class or degree, or define more serious misdemeanor offenses as gross misdemeanor. And these classifications, they help determine the severity of the punishment. And what's an example of a misdemeanor? Let's say Dave is convicted of simple assault, and this offense carries a maximum fine of 1,000 and maximum jail time of 6 months. What is this? This is a misdemeanor. How about felonies? You see, felonies are the most serious type of criminal offense. Felonies often involve serious physical harms or threat of harm to the victims, but they also include offenses like white-collar crimes and fraud schemes. Offenses that otherwise are misdemeanors can be elevated to the level of felonies for second time or third time offenders. A felony conviction, like a misdemeanor conviction, may not result in time behind bars, but felonies carry potential imprisonment that ranges from the time in prison, if a year is often the low end, to a life in prison without parole or even death penalty. As with misdemeanors, states may also subdivide felonies by class or by degree. For example, felony example 1, let's say Randy is convicted of felony assault with a deadly weapon, even though the bottle that he threw at another patron in a tavern missed its intended target. So even though Randy has failed to injure the intended victim, his behavior was intended to and did create a risk of serious physical injury. And let's take another example. Laura had 2 prior shoplifting convictions, let's say, before being arrested for yet another shoplifting offense. And the state law allows prosecutors to charge shoplifting as a felony if the merchandise was worth a certain amount and the defendant has 2 or more prior shoplifting convictions. In this case, therefore, the prosecutor can charge Laura with felony shoplifting. We have discussed about the classifications of crime, and now we will deep dive into the world of white collar crimes. So what is a white collar crime? You see, this word white collar crime, it was reportedly coined in 1939. And this term white collar crime is now synonymous with the full range of frauds committed by the business corporations and the government professionals. And these crimes are characterized by deceit, concealment, or violation of trust, and they are not dependent on the application or threat of any physical force or violence. There's no physical force or violence. There's no murder. These are mostly financial crimes. And in criminology, you see white collar offenses, they differ from blue collar crimes in that the blue collar crimes are any crime committed by an individual from a lower social class. And blue collar crimes are often considered more obvious and easily detected by the law enforcement. Whereas white collar crime, on the other hand, is associated with sophisticated crime that's committed by someone of a higher level social class. And white collar crimes, they generally involve criminal activities committed by people in the regular course of their business, and they generally involve bribery, extortion, fraud, and embezzlement. And these crimes usually end in financial gain for the perpetrator. And you see, not every crime involves a smoking gun or a murder or a robbery. Some crimes are committed right under the victim's nose without a single shot being fired or someone being dead. And white collar crimes are criminal acts that are performed by the people, as I said earlier, in the course of regular business, and they're committed for financial gain. And these types of crimes generally go undetected for quite a long period of time and can cost citizens millions of dollars. And thus, white collar crimes, you see, they generally encompass a variety of non-violent crimes that's committed in commercial situations for financial gains. And now we will be taking a look at some of the specific white collar crimes. What are these? The first is bribery. You see, corrupt solicitation, acceptance, or transfer of value in exchange for official action or favor is called bribery. And bribery refers to the offering, giving, soliciting, or receiving of any item or of value as a means of influencing the action of an individual holding a public or a legal duty or an office. And this type of action results in matters that should be handled objectively and being handled in a manner best suiting the private interest of the decision maker. And bribery, remember, it constitutes a crime, and both the offerer and the recipient of the bribe can be criminally charged. Next is extortion. And extortion occurs when a person coerces an institution or another person into giving up property, money, or services. An example is when a gang forces the store owners to pay protection money. And an example is when a blackmail victim pays money to keep someone from publicly divulging information that can potentially harm their reputation. Next is fraud. Fraud is one of the most common type of white-collar crimes. You see, fraud cases, they often involve the perpetrator imitating someone else in order to take funds out of the real owner's bank account. And fraud may also help a perpetrator commit identity theft. Next is securities fraud. Securities fraud, it includes theft from manipulation of the market or theft from the securities accounts, as well as wire fraud. Next is insider trading. Insider trading is basically the trading of a company's stocks or other securities by individuals with access to confidential or non-public information about the company. And taking advantage of this privileged access is considered a breach of the individual's fiduciary duty. You see, a company is required to report trading by corporate officers, directors, or other company members with significant access to privileged information to the Securities and Exchange Commission, that is the SEC, or be publicly disclosed. And federal law, it defines an insider as a company's officers, directors, or someone in control of at least 10% of the company's equity securities. And Congress, you see, has criminalized this insider's use of non-public information under the theory that the use fraudulently violates a fiduciary duty with which the company has charged the insider. And from an economic public policy perspective, the scholars also consider insider trading socially undesirable because it increases the cost of capital for security traders and therefore it depresses the economic growth. Next is false pretense. False pretense involves generally defrauding someone by using false statements for financial gain. It generally involves the transfer of personal property. A fraud that was recently making news, it involved the selling of supposedly winning lottery tickets to unsuspecting victims. To elaborate, what happened here was the defendant holds what he claims to be a winning lottery ticket in his possession. He approaches his victim and requests that the victim pay him a portion of the winning proceeds in exchange for the ticket. And while most people would run from a scammer with a story like this, the defendant explains further that he cannot cash in the ticket because of an immigration issue or a tax lien. And once he gains the trust of the victim, money is exchanged, and all along the defendant knows that the ticket is worthless. The victim, however, believes differently, and by the time the victim reaches the lottery center to find out that the ticket is worthless, the defendant has already disappeared. The defendant is miles and miles away. Next is forgery. What is forgery? This is basically a crime where someone falsely alters or changes a document or creates a document or a signature that is not their own with the intent to defraud another person. And this sounds confusing, but it is really as simple as signing a check with the name of someone else with the intent of cashing it. How about Ponzi scheme? You see, Ponzi scheme was named after Charles Ponzi. He was a con man who reportedly made $250,000 a day through his mail coupon fraud in the 1920s. And a Ponzi scheme is basically a type of investment scam that promises high returns for little to no risk. And people or the organizations that are engaged in Ponzi schemes, they focus their effort on attracting new investors to pay the older ones. It's a pyramid scheme, kind of a pyramid scheme. And this scheme falls apart when the new customers stop coming in and the flow of new investment, it dries out. How about embezzlement? You see, embezzlement is the fraudulent taking of personal property by someone to whom it was entrusted. And it is most often associated with the misappropriation of money. And embezzlement can also occur regardless of whether the defendant keeps the personal property or transfers it to a third party. And thus, embezzlement, it happens when a person entrusted by another employer or another person to handle money or property uses their position to misappropriate the funds. And an example of embezzlement when an employee finds ways to funnel company money into their bank account. And another is when a politician spends campaign funds for their own personal expenses. Next is computer crimes such as hackers and cyber terrorists. You see, fraud through the criminal use of a computer or the internet, it can take many different forms. So hacking is the common form in which the perpetrator, he uses technological tools or software to remotely access a protected computer or a system. And the common form, it involves the interception of an electronic transmission unintended for the interceptor, such as passwords, credit card information, or other types of identity theft. And examples of computer internet fraud in action can be such as email requesting money in return for small deposits, or emails attempting to gather personal information such as account number, social security number, and password, which is also known as phishing, or installing spyware or malware to engage in data mining, or violating copyright laws by copying information with the intent to sell it, or hacking into or illegally using a computer to change information such as, let's say, grade, work reports, etc., or sending out computer virus or worms with the intent to destroy or ruin another person's computer. So you see, to summarize, due to the internet, an increasing cause of white-collar crimes today is cybercrime. And this type of crime, it involves basically, as I said earlier, collecting credit card information or personal data through the use of computers. And some nations even use sophisticated attacks in order to discover classified information that other countries are attempting to hide. And some individuals or nations may also make computer viruses that infect vulnerable computers and send spam or perform specific tasks that may help to generate funds or gather information. How about bankruptcy fraud? You see, bankruptcy fraud is a white-collar crime that commonly takes 4 general forms. What are these forms? First, a debtor conceals assets to avoid having to forfeit them. Or second, an individual intentionally files false or incomplete forms, including false information on a bankruptcy form that may also constitute a perjury. Or 3, an individual can file multiple times using either false information or real information in several jurisdictions. And the 4th type of bankruptcy fraud is when an individual bribes a court-appointed trustee. And why is this a crime? You see, nearly 70% of all bankruptcy fraud, it involves the concealment of assets. Bankruptcy in itself is not bad. You see, creditors can only liquidate assets listed by the debtor. Thus, if the debtor fails to reveal certain assets, he can fraudulently keep them despite owing an outstanding debt. And for further concealment, the debtor might even transfer the undisclosed assets to friends, relatives, or associates, or to an undisclosed location, or even out of the country so that it cannot be traced or found. And fraudulent concealment, it makes the loans more expensive because it raises the risk and the cost associated with lending, and creditors will obviously pass on those costs to the other hopeful borrowers. That's why bankruptcy fraud is a big problem. What about mail fraud? You see, mail fraud occurs when the US mail is used in furtherance of a criminal act. And in order for a defendant to be convicted for mail fraud, certain elements must be satisfied. What are these elements? First, the defendant must have been engaged in a scheme to defraud. Second, the scheme must have involved material misstatements or omission. Third, the scheme resulted or would have resulted upon completion in the loss of money, property, or honest services. Fourth, the defendant must have used the US mail in furtherance of the scheme to defraud. And fifth, the defendant actually used or caused the use of the US mail. What about money laundering? You see, money laundering, it refers to a financial transaction scheme that aims to conceal the identity, source, and destination of the illicitly obtained money. The money laundering process can be broken down into 3 stages. What are these? First, the illegal activity that garners the money, places it in the launderer's hand. Second, the launderer passes the money through a complex scheme of transactions to obscure who initially received the money from the criminal enterprise. And third, the scheme returns the money to the launderer in an obscure and indirect way. How about intellectual property theft or piracy? You see, intellectual property theft involves robbing people or companies of their ideas, inventions, and creative expressions, otherwise known as intellectual property. These are all intellectual property, and it can include everything from trade secrets and proprietary products and parts to movies, music, and software. You see, there are 4 main types of intellectual property. They are trade secrets, trademark, copyright, and patents. And intellectual property can include everything from proprietary products and parts to movies, music, web content, business process, as well as software. Intellectual property theft, it can result in serious economic damage, loss of competitive edge, and also decreased business growth. And synonymous with intellectual property theft is counterfeit and piracy. Whereas a counterfeit goods is an unauthorized imitation of a branded good, piracy, it consists in making an unauthorized exact copy, not a simple imitation, it's an unauthorized exact copy of an item covered by an intellectual property right. How about economic espionage and trade secret theft? You see, in general terms, economic espionage is the unlawful targeting or acquisition of sensitive financial, trade, or economic policy information, or proprietary economic information or technological information. And this act of receiving, purchasing, or possessing a trade secret known to have been stolen or misappropriated, as well as any attempt or conspiracy to commit economic espionage, are punishable as a federal crime under the Economic Espionage Act of 1996. How about tax evasion? You see, tax evasion is using illegal means to avoid paying taxes. Typically, tax evasion schemes involve an individual or a corporation misrepresenting their income to the IRS or the Internal Revenue Service. And the misrepresentation may take the form either of underreporting income, or inflating the deductions, or hiding money and its interest altogether in offshore accounts. And the US government projects that fiscal year 2007, it resulted in the government losing 345 billion because of just tax evasion. How about phone and telemarketing fraud? You see, phone and telemarketing fraud, it refers to any type of scheme in which a criminal communicates with the potential victim via the telephone. And because nowadays many reputed companies also use telemarketing to conduct business, criminals can often effectively use the same method as a way to obtain the victim's credit card information or identity, and then use this information to make unauthorized purchases elsewhere. And unfortunately, the victims have difficulty distinguishing between reputed telemarketers and real telemarketers and scam artists. And frequent victims of telemarketing scams, they include the poor people, the elderly, and the immigrants who do not have strong English skills. Right? And what about the healthcare fraud? You see, healthcare fraud is a type of white-collar crime that involves the filing of dishonest healthcare claims in order to turn a profit. And fraudulent healthcare schemes come in many forms. For example, practitioner schemes, it includes individuals obtaining subsidized or fully covered prescription pills that are actually unneeded and then selling them on the black market for a profit, or billing by the practitioners for care that they never rendered, or filing duplicate claims for the same service rendered, or altering the dates, description of services or identities of members or providers, or billing for a non-covered service such as a covered service, or modifying medical records, or intentional incorrect reporting of diagnosis or procedures to maximize the payments, or use of unlicensed staff, or accepting or giving kickbacks for member referrals, or waiving member co-pays, and prescribing additional or unnecessary treatment. And members can also commit healthcare fraud by providing false information when applying for programs or services, forging or selling prescription drugs, using transportation benefits for non-medical related purposes, and loaning or using another insurance card. And you see, when a healthcare fraud is perpetrated, the healthcare provider passes the cost along to its customers. And because of this pervasiveness of the healthcare fraud, statistics now show that 10 cents of every dollar spent on healthcare, it goes towards paying for fraudulent healthcare claims. Now we will take a look at some of the top CEOs of companies who went rogue.
Crime has an unfortunate association with business in most developed countries. Welcome to WatchMojo.com, and today we're counting down our picks for the top 10 infamous CEOs who went to jail.
Stanford ran up the debt about 1 month before regulators shut down his financial empire.
Before we begin, we publish new videos every day, so be sure to subscribe for more great content. For this list, we'll be looking at high-level executives who are ultimately locked away for manipulative, corrupt, or otherwise illegal endeavors within their respective companies. Whether the punishment fits the crime or not is a discussion for another time, but actual hard jail time must have been served to qualify. Also, you don't need to be a company's chief executive officer to commit serious white-collar crime, so high-ranking executives have been considered as well. Number 10, Callisto Tanzi. In 2003, the Italian food and dairy corporation Parmalat filed for bankruptcy. With over $14 billion in debt, this step only made sense. But it soon emerged that sinister activities were taking place beneath the surface. Mr. Tanzi was a trusted founder of Parmalat, so trusted that no one suspected he'd embezzled over 800 million euros from the company. The businessman was sentenced to 10 years in prison in 2008. A series of appeals and additional sentences followed, which upped that time to about 17 years. To this day, the Parmalat scandal remains the largest bankruptcy in European history. Number 9, Sanjay Kumar. Kumar worked his way up the corporate ladder at Computer Associates International and eventually became CEO in 2000. His term in the prestigious position was short-lived, however. He was investigated for fraud 4 years later, and it was revealed that Sanjay had been cooking the books, leading to billions of dollars of discrepancy.
Who can you trust to do the forensic accounting?
One method he used in his accounting gymnastics earned the nickname the 35-day month. In 2006, the former CEO was finally convicted of obstruction of justice and securities fraud, calling his cover-up, quote, the most brazen and comprehensive in the modern era of corporate crime. The judge sentenced him to 12 years in prison. Oh, and he has to pay almost $800 million in restitution. Number 8, Richard M. Scrushy. Accounting fraud is hardly a sexy crime, and perhaps this is one reason why so much of it goes unnoticed. Scrushy founded a healthcare company in Alabama called Health South in 1984 and gained notoriety for illicit accounting practices in 2003.
You have five people
that have made these claims out of 50,000 people.
Scrushy's first trial for fraud, money laundering, and conspiracy ended in an acquittal in 2004. But a new federal trial in 2005 ended with convictions for bribery, fraud, and conspiracy. Scrushy was sentenced to 7 years in prison. He was later found guilty in a civil trial and ordered to pay $2.87 billion in damages. He was released in 2012 from federal prison and has actually been outspoken about the government's lackadaisical approach to white-collar crime nowadays.
I'm not mad at anybody. I'm not upset about that. I'm not drinking any poison.
Number 7, Martin Grass. When you think of Scranton, Pennsylvania, you may think of the cozy town with the lovable working-class employees as seen in The Office. But the story behind Scranton native drugstore chain Rite Aid paints a different picture. From its humble beginnings in the 1960s, the business grew significantly over the next 3 decades. But it took a turn for the worse when its founder's son, Martin Grass, took over in 1995. Grass thought it would be wise to systematically overstate Rite Aid's earnings in an effort to grow the company. This almost destroyed the drugstore chain. Grass was caught up in a $1.6 billion scandal and sentenced to 8 years in prison.
So according to studies, there is one food that raises testosterone levels by 52%.
Number 6, Walter Forbes. Ascendant Corporation was formed from a merger of Hospitality Franchise Systems and CompuCard International, and might have gone on its merry way had they not allowed Walter Forbes to become CEO. Merging companies is a great way to create synergies that make a company altogether more efficient, in theory. Unfortunately, Ascendant Corporation soon found that CompuCard's efficiencies had been, shall we say, overstated by its then CEO Forbes. He claimed to have unknowingly reported $500 million in imaginary earnings, but supposed ignorance is hardly bliss in this situation. Forbes was eventually sentenced to 12 years in prison and $3.28 billion in damages. Number 5, Dennis Kozlowski.
Everything I was doing for 27 years.
Tyco is an international business that focuses largely on security solutions and fire protection. Despite this, its internal security was clearly lacking in at least one instance. When images of the lavish Wall Street lifestyle of the 90s come to mind, know that Kozlowski was a poster boy for this image. Before indictment, he owned a $30 million New York City apartment, complete with $6,000 shower curtains. Turns out that was in part thanks to a scheme that gave him over $80 million in unauthorized bonuses. Kozlowski was sentenced to a minimum of 8 years and 4 months, 2005.
And I think a juror sitting there just would have to say, all that money, he must have done something wrong.
Number 4, Jeffrey Skilling.
Welcome, everyone, to Enron Gas Services Solutions Day.
When phrases like white-collar crime are brought up, Enron is typically one of the first associations to be made. Skilling was one of the main perpetrators behind this catastrophe, and it started with a bookkeeping technique known as mark-to-market accounting, a technique that records assets based on expected values as opposed to actual values. The next step was creating an Enron subsidiary to sweep all debt under the rug when this proved to be inadequate.
I absolutely, unequivocally thought the company was in good shape.
Upon discovery, $405 million in losses were reflected overnight, and Skilling was slapped with 24 years in prison. Number 3, Bernard Evers. Evers helped create Long Distance Discount Services Incorporated, a telecommunications firm that eventually became WorldCom in the coming years.
WorldCom. Want confidence? You'll find the path very clearly marked.
His Greek tragedy began to unfold as Icarus flew too close to the sun in 1999, with an announcement that WorldCom intended to purchase Sprint. Antitrust laws resulted in the deal not going through, and subsequently in a massive drop in WorldCom stock. Instead of downsizing or waiting it out, Evers worked with a team to employ elaborate accounting gymnastics, which resulted in $11 billion overstated on the book.
We would never have integrated. Nobody has combined billing systems for that.
This did not bode well for the company, nor for the businessman himself, who is working on a 25-year sentence in Louisiana. Number 2, Alan Stanford.
My number one goal is to fight this thing for the investors.
Stanford actually made his first attempt at professional success with a bodybuilding gym in Texas. This eventually failed, and he moved into finance soon after, ultimately becoming chairman of the Stanford Financial Group. They began to catch the attention of the SEC and FBI due to consistently high returns compared to the market. When the Stanford financial offices were raided in 2009, the cover was blown off a massive Ponzi scheme.
Everything seemed reasonable.
Stanford still publicly states that the company never swindled anyone, but his unwillingness to acknowledge clear facts did not stop him from receiving a 110-year sentence. Well, at least he'll have plenty of time to pursue his bodybuilding dream. Before we unveil our number one pick, here are some honorable, or in this case, dishonorable mentions.
No, I'm a tough person from the start. I've always been a tough person. It wasn't something that happened really involving the company. And it is something that I wish had not happened.
Number one, Bernie Madoff. He's behind the largest financial fraud in U.S. history. Bernard L. Madoff Investment Securities, LLC, was highly respected on Wall Street, and everyone from individual investors to charities was more than happy to entrust him with their life savings. His returns were considerable, but every bit of this was fabricated, and Madoff was effectively taking money from investors' pockets.
You could potentially be in an investment that your advisor is making money off of losses on.
He was eventually sentenced to 150 years in federal prison, but irreparable damage had been done to countless victims in the process. Today, many think of him as an embodiment of corporate greed, Wall Street corruption, and capitalism run amok.
At one point, he said something strange to me. He said, every once in a while, I find myself smiling, and I'm horrified.
Do you agree with our picks? Check out these other great clips from Watch Mode.
Okay, now we will talk about, let's discuss about criminal procedure. You see, to understand criminal procedure, we have to first understand how criminal law differs from civil law. For starters, since crimes are public injuries, you see they are punishable by the government. It is the government's responsibility to bring the charges against the criminals. And in fact, private citizens may not prosecute each other for the crime. And when a crime has been committed, for instance, if someone is, let's say, the victim of fraud, the government will collect the evidence and file charges against the defendant. And when someone is charged with committing a crime, he or she is charged by the government in an indictment. And the victim of the crime is a witness for the government, but is not the prosecutor of the case. And in a criminal case, the defendant is also presumed to be innocent until and unless he or she has been proven guilty. And this presumption of innocence means that the state must prove the case against the defendant before the government can impose a punishment. And if the state cannot prove its case, then the person charged with the crime will be acquitted. This means that the defendant will be released and he or she may not be tried for that crime again. And the burden of proof in a criminal case, always note that it is the prosecution's burden, and the prosecution must prove its case beyond a reasonable doubt, This means that the defendant does not have to prove anything because the burden is on the government to prove its case. And additionally, the evidence must be so compelling that there is no reasonable doubt as to the defendant's guilt. And to be convicted of a crime, someone must possess the required criminal state of mind or mens rea, and likewise the person must have committed a criminal act, also known as actus reus. And compare this to the standard of proof in a civil trial, which requires the plaintiff to prove the case only by a preponderance of the evidence. This means that the evidence to support the plaintiff's case is greater or weightier, or has more weight than the evidence that does not. And it's useful to think of the criminal standard of proof, that is beyond a reasonable doubt, as something like 99% certainty with 1% doubt. And compare this to the preponderance of evidence, which we might think of as 51% in favor of the plaintiff's case, but up to 49% doubt. And this means that it is much more difficult to successfully prosecute a criminal defendant than it is to bring a successful civil claim. And since a criminal action and a civil action may be brought against a defendant for the same incident, these differences in burdens of proof can also result in verdicts that seem at first glance to contradict each other. And in fact, perhaps the most well-known case in recent history in which this very outcome had happened was the O.J. Simpson trials. You will remember, if you have been following the O.J. Simpson case and trials, you will remember that Simpson was acquitted of murder in the criminal trial, but he was found liable for wrongful death in a subsequent civil action. You see, this extra burden, it reflects the fact that the defendant in a criminal case stands to lose much more than a defendant in a civil case. Even though it may seem like a very bad thing to lose one's assets, in a civil case, the loss of personal liberty or even life is considered to be a more serious loss. Therefore, more protections are afforded to the criminal defendant than are afforded to defendant in a civil proceeding. And because so much is at stake in a criminal case, our due process requirements are very high for anyone who is a defendant in a criminal proceeding. And due process procedures are not specifically set out by the Constitution, remember that, and they vary depending on the type of penalty that can be levied against the defendant. For example, in a civil case, the due process requirement might simply be, let's say, a notice and an opportunity to be heard. And if the government intends to revoke a professional license, then the defendant might receive notice by way of a letter. The opportunity to be heard might exist by way of a written appeal. On the other hand, in a criminal case, however, the due process requirements are higher. And why? Because the criminal case carries the potential for the most serious penalties. Now let's take a look at some of the constitutional rights which are relevant to criminal proceedings. You see, it's important to know always that a person accused of a crime has several rights, like we just now discussed, and many of which are guaranteed by the US Constitution. Many crimes are, of course, state law issues. However, many provisions of the US Constitution's Bill of Rights, which contains the rights of concern to criminal defendants, have been incorporated as applicable to the states, and this is known as the incorporation doctrine. So what are these constitutional rights? First is the Fourth Amendment. It provides a prohibition against illegal searches and seizures. This means that if the evidence were obtained in violation of the Fourth Amendment, it cannot be used against the defendant in a court of law. And for the Fourth Amendment requirements to be met, the government must first obtain a search warrant to search a particular area for particular items if there is a reasonable expectation of privacy in the area to be searched. The search warrant is issued only on probable cause, and probable cause arises when there is enough evidence, such as true corroborating evidence, to reasonably lead to the belief that someone has committed a crime. And also remember that in the business context, it is important to remember that the administrative agencies in certain limited circumstances may conduct warrantless searches of closely regulated businesses such as junkyards, where many stolen cars are disassembled for the parts that can be sold. How about the Fifth Amendment? You see, the Fifth Amendment guarantees the right to avoid self-incrimination. And this right means that the government cannot torture someone accused of committing a crime. Obviously, someone under the physical and psychological pain of torture will admit to anything, and this might be a strong incentive to allow torture if the government wanted someone to confess to a crime. However, the Fifth Amendment guarantees that the people can choose to remain silent, and no one is compelled to testify against himself or herself to make self-incriminating statements. What about the Sixth Amendment? You see, the Sixth Amendment, it guarantees that criminal defendants are entitled to an attorney during any phase of a criminal proceeding where there is a possibility of incarceration. This means that if a defendant cannot afford an attorney, then one is appointed for him or her at the state's expense. What about the 8th Amendment? You see, the 8th Amendment, it prohibits cruel and unusual punishment. We do not employ many techniques that were once used to punish people who committed the crime. For instance, these days we do not draw and quarter people, which was, of course, a practice in England during the Middle Ages. Recently, however, the question of the use of torture by the United States against the aliens on foreign soil has been a hot topic, and many people believe that our 8th Amendment protection should be extended to everyone held by the US authorities, whether they are on US soil or not. And the 14th Amendment also, remember, it extends the right to due process in all the state matters and extends most of the constitutional rights to the defendants at the state level. Now we will look at the criminal justice system and the process. You see, the criminal justice process, it varies among the states and the federal criminal justice system, and it has its own procedures and rules as well. However, for the most part, the criminal justice systems in all jurisdictions are comprised, they are all comprised of the same basic components. And now we will take a look at the general overview of the various steps, court hearings, and procedures that the criminal prosecutions typically involve before the appeal stage. So what are these stages? As you can see here, these are investigation, arrest, charging a crime, which consists of two components, information and indictment, followed by arraignment stage, which is composed of the advisement of rights, the bail and release conditions, and entering a plea. And then comes the preliminary hearing stage and the discovery and pretrial motions, followed by the plea hearing, which comprises of entering a plea or a plea bargaining. And then we come to the trial stage, and then the sentencing hearing, and finally the appeal process. Now let's take a look at them one by one. So first is the investigation. You see, the investigation of a crime, it begins when a police becomes aware of a suspected criminal activity. And this can occur in a variety of circumstances, including a witness or a victim making a report or a complaint, or an officer simply observing someone engaging in a suspicious activity. And after suspecting a crime, the police might need to gather more evidence or information by conducting interviews with witnesses, collecting physical evidence, and taking photographs and videos. In some situation, an officer might apply to a judge also for a search warrant, which authorizes entry into a physical location, such as a home or a business, to look for evidence. And the officers can also obtain search warrants for vehicles, phone records, blood, urine, and the DNA. Next is the arrest. You see, generally, a police officer can arrest a suspect for a crime if, number one, there is a probable cause, that is a rational factual basis to believe that the person committed a crime. Two, a crime was committed in the officer's presence. Or three, there is a warrant for the person's arrest. And the circumstances in which an arrest warrant is required, it varies from jurisdiction to jurisdiction. Next is charging a crime. The formal criminal justice process, it actually begins with the filing of a criminal charge through an information or grand jury indictment. So what is this information? You see, after reviewing the investigative reports and the evidence, a prosecutor can then charge a criminal offense by filing an information, which is also sometimes called a complaint. And in some states, the prosecutors can charge only misdemeanor crimes with an information. And in states that allow felony crimes to be charged by filing an information, a preliminary hearing is also generally required. And what is indictment? You see, in some jurisdictions, felony crimes are presented to a grand jury, which is basically a group of private citizens who conduct the proceedings in secret. A prosecution explains the law to the jury and presents evidence, and the grand jury votes on whether there's enough evidence to indict the person suspected of committing the crime. And then there is arraignment. The next stage is arraignment. So after the criminal charges have been filed, the first court appearance of the accused is typically the arraignment. Generally, the arraignment must be held within a certain time period after the defendant has been arrested. And this time period is typically quite short. For instance, it might be 2 days if the suspect is being held in the jail. And here we have to know 2 things. One is the advisement of rights. You see, at the arraignment, the judge normally advises the defendant of the charges. That is why it's called advisement. Advises the defendant of the charges and the maximum and the minimum penalties and certain constitutional rights that all criminal defendants are afforded. For example, as I discussed earlier, criminal defendants, they have the right to be represented by an attorney. If a defendant cannot afford an attorney, the court will appoint one at no cost. And then there is also bail and release conditions at the time of arraignment. So this is basically when the judge will discuss the bail, if the state uses a bail system, and release conditions at the arraignment. And in some cases, you see a defendant who has been arrested and charged with a crime will get out of the custody before the arraignment by posting a bail or being released without a bail, which is commonly known as own recognizance release or conditional release. And if the defendant isn't released after being booked at the jail, the judge may consider release at the time of the arraignment. And defendants who are released with or without posting a bail must agree to abide by certain release conditions. And what are these release conditions? These release conditions might include the defendant agreeing to, number 1, appear in the court for all the scheduled proceedings, 2, not leave the state while the proceedings are pending, and not contact a witness or an alleged victim. And when deciding whether to grant a release, the judges will also often consider the defendant's criminal history, the ties to the community, and the community safety as a whole. And there's also the third, that's entering a plea. You see, in some jurisdictions, the defendant must enter a plea of guilty, not guilty, or no contest at the arraignment. The first plea in a case is often not guilty. And to plead no contest at any point, a defendant might need the judge's permission, the prosecution's agreement, or both. And in other jurisdictions, the defendant doesn't enter a plea until the plea hearing. And the next stage is the preliminary hearing. You see, in some states, at some point after the arraignment, a defendant who is facing felony charges and who wasn't indicted is entitled to a preliminary hearing at which a judge determines whether there's probable cause, that is enough evidence to support the charges. And typically the prosecution will present witnesses at this kind of hearing, and the defendant gets the chance to cross-examine them. And if the judge decides that there's probable cause, the case will proceed. If on the other hand the judge decides that there is not enough evidence of the defendant's guilt for probable cause, the charges will be dismissed. And then we have the discovery and the pretrial motions. And during the discovery phase of the criminal process, the prosecutor and the defendant's attorney, they will be exchanging information about the case. And the discovery generally will include the police report, the photographs, the videos, and any other information that the parties plan to use at the trial. And the prosecution, always remember, also has an obligation to provide any information in its possession that might be beneficial to the defendant's case. And in addition to providing and receiving discovery, the parties might file the pretrial motions during this early stage of the criminal process. The motions made by the prosecutor might include a request for the defense to disclose discovery or for the judge to admit certain evidence at the trial. And remember that the motions made by the defense also might include a request to dismiss the charges or to suppress certain evidence. And if the lawyers file any pretrial motion, the judge will generally set a hearing or hearings before the trial and at them make decisions on the relevant issues. This is discovery and the pretrial motion stage. Discovery and the pretrial motion stage. Then we have the plea hearing. So the plea hearing is often the next court appearance in the jurisdictions that do not require a defendant to enter a plea at the arraignment. And here at the time of plea hearing, there are two types. One is entering a plea, that is at the plea hearing, a defendant might plead guilty or no contest after reaching a deal with the prosecution. And if the defendant pleads not guilty, the judge might set a date for the potential trial. And what is plea bargaining? You see, generally a prosecutor will provide a plea offer to the defendant and some negotiations will take place before the plea hearing. And the prosecutors can make plea offers at any point in the proceeding, remember, even at the point of the defendant's first court appearance. And instead of going to trial, a defendant can accept a plea offer and plead guilty or no contest. And in exchange for a defendant's guilty or no contest plea, the prosecutor might dismiss other charges also or recommend a particular sentence or do both. And then we have the trial. You see, although most cases are resolved through plea bargaining, criminal defendants have a constitutional right to a jury trial for most charges. And trial procedures, remember, it varies by jurisdiction. But the jury trial typically begins by both parties selecting 6 to 12 jurors from a pool of potential jurors. And the jurors that are selected will decide the case. The process of questioning these possible jurors is known as voir dire. And once a jury is selected, the prosecutor and the defense will give their opening statements, which are basically previews of the evidence that each party intends to present. And after the opening statement, each party will present its evidence. And trial evidence might also include the testimony of witnesses. It can be direct as well as cross-examination and physical evidence. For instance, the gun that was used in a robbery, as well as photographs and videos. And after the lawyers for both parties, they present their evidence, they will give their closing arguments, and the case will go to the jury for deliberation. And the jury will privately deliberate until they reach a verdict. And this trial is followed by the sentencing hearing. So if the jury finds the defendant guilty or the defendant pleads guilty or no contest, the next court appearance is the sentencing hearing. And this sentencing can also happen at the same hearing where the defendant had pleaded guilty or no contest. And when a defendant is convicted at the trial, or let's say the parties don't have a sentencing agreement, the judge will decide the sentence within the allowable range under the law. For instance, state law might specify that defendants convicted of a burglary can be sentenced to 2 to 6 years in prison and up to 5,000 in fine. And the judge might also have leeway to sentence the defendant to probation. And for defendants who have accepted a plea offer, the sentence will normally simply be what the parties have agreed to, as long as the sentence is within the parameters of the jurisdiction's sentencing laws. However, the judge generally has the final authority in the sentencing phase and can ultimately sentence a defendant to something different than what the parties have agreed to. And remember that when sentencing a defendant, the judge will typically consider, in addition to the circumstances of the current offense, such factors I think I got disconnected. I'll continue. So during the sentencing hearing, the judge will consider several factors. As I said earlier, the defendant's criminal history, the employment or the financial situation of the defendant, the education level of the defendant, and the substance abuse history of the defendant. And additionally, in most jurisdictions also, the victims have a right to be present and give a statement, which is known as the victim statement at the time of sentencing. And finally, we have the appeal process. So you see, after a defendant is found guilty, he or she can appeal to the highest state court if it is a state prosecution, or the court of appeals if it is a federal prosecution, if the defendant believes that they were wrongly convicted or the sentence was too harsh. An appeal is not another trial, but an opportunity for the defendant to try to raise specific legal errors that might have occurred at the trial. A common appeal is always that a decision from the judge was incorrect, such as whether to allow certain evidence or to impose a certain sentence. And appeals are also complicated and can sometimes result in the case going back to the trial court. A conviction can often be reversed, a sentence can be altered, or a new trial may be ordered altogether if the court of appeals decides that the particular course of action. So we are done now with the criminal justice process. Now we will take a look at some of the legislations that combat white collar crimes. What are these? The first one is the RICO. RICO is also known as the short form for the Racketeer Influence and Corrupt Organizations Act. So basically this is a United States federal law that provides for extended criminal penalties and a civil cause of action for the acts performed as part of an ongoing criminal organization. It is an act which was published in 1970 relating to the control of organized crime in the United States, and it allows prosecution and the civil penalties for racketeering activity performed as part of an ongoing criminal enterprise. And such activity may include illegal gambling, bribery, kidnapping, murder, money laundering, counterfeit, embezzlement, drug trafficking, slavery, as well as a host of other unsavory business practices. And to convict a defendant under the RICO, the government must prove that the defendant had engaged in 2 or more instances of racketeering activities, and that the defendant had directly invested in, maintained an interest in, or participated in a criminal enterprise affecting interstate or foreign commerce. And to date, this law has been used to prosecute members of the mafia, the Hells Angel motorcycle gang, and anti-abortion group, among many others. And remember that in addition to being held civilly liable under RICO, a violator may also be subject to RICO's criminal penalties. And a person found to have violated the RICO may be subject to a fine of up to $25,000 per violation, imprisonment for up to 20 years, or both. Then we have the False Claims Act. So this act was originally published in 1863, and it was of course amended several times thereafter. And this False Claims Act is also known as the Lincoln Law. It is an American federal law that imposes liability on the persons and companies who defraud government programs. It is a federal government's primary litigation tool to combating fraud against the government. And this is a federal law that makes it a criminal for any person or organization to knowingly make a false record or file a false claim regarding any federal healthcare program, and which includes any plan or program that provides any health benefits, whether directly through insurance or otherwise. It is funded directly in whole or in part by the US government or any state healthcare system. And violations under this Federal False Claims Act can result in, remember, significant fines and penalties. And financial penalties to the person or organization includes recovery of 3 times the amount of the false claim made, plus an additional penalty of anything between $5,500 to $11,000 per claim. Then we have the Sarbanes-Oxley Act of 2002, which is a US federal law that aims to protect investors by making corporate disclosures more reliable and accurate. And this act was actually spurred by major accounting scandals, and billions of dollars were lost as a result of this financial disaster. If you remember, this act was passed by the Congress to curb widespread fraudulence in corporate financial reports and scandals that rocked the early 2000s. If you remember the Enron and the WorldCom that we saw in a recent video. And this act, the Sarbanes-Oxley Act, now holds the CEOs of companies responsible for their company's financial statements. The whistleblowing employees are given job protection, and more stringent accounting standards are followed because the act holds the CEOs personally responsible for the errors in accounting audits. So the primary goal of the Sarbanes-Oxley Act was to fix the auditing of and oversee the US public companies consistent with its full official name, and it is actually called the Public Company Accounting Reform and Investor Protection Act of 2002. And in the beginning, many had thought that the Sarbanes-Oxley Act was too punitive and costly to put in place, and they had worried that it would make the United States a less attractive place to do business. However, in retrospect, it's clear that this Sarbanes-Oxley was on the right track. And this highlight of this act is section 404, remember, which requires corporate executives to certify the accuracy of financial statements personally. And if the Securities and Exchange Commission finds violations, the CEOs of the companies could face 20 years in jail, because section 404 makes managers maintain adequate internal control structures and procedures for financial reporting. And also the company's auditors have to attest to these controls and disclose material weaknesses. And we have finally the state whistleblower protection laws. You see, a whistleblower is an employee who reports a violation of the law by his or her employer. And almost all the states and the federal government as well have laws protecting whistleblowers from retaliation for filing a claim or reporting a violation. So these whistleblower protection laws are either public or private sector employees or for both. However, these laws are very different. So it is important for both the employers and the employees to know the law in their state. And the biggest difference among the states is to whom the violation may or must be reported. You see, in many states, the employees in the private sector, they receive protection from retaliation only if they report the wrongdoing to an external governmental body. And other states take the opposite approach, and it requires the whistleblower to report his suspicions first internally to his supervisors. And also remember that almost no states protect the employees who choose to go to the media with their reports of their employer wrongdoings.